closing arguments. I'm Julia Jenae, and tonight for Vinnie Politan, we begin this hour in Delphi, Indiana, in the case against Richard Allen. He's accused of murdering two young girls, Abigail Williams and Liberty German, this back in February of 2017. Since then, this case has been anything but typical. We've seen accusations of leaked crime scene images, theories of a cult-like ritualistic killing, defense attorneys being kicked off the case, back on again, Supreme Court hearings, those same defense attorneys being reinstated, and much more. And just as the dust was seemingly beginning to settle, we have some more legal drama for you tonight. We begin this evening with the defense and their submitting of a motion for an early trial. Take a look. The defendant, Richard M. Allen, in this filing, his counsel says, is moving the court for an early trial date within 70 days pursuant to criminal rule in Indiana 4B1. So let's take a look at that criminal rule that they're citing in that motion. Indiana's criminal rule, the criminal procedure rule, says that if a defendant is held in jail on a pending charge, like Richard Allen is, that he can move for an early trial. If such a motion is filed, a trial must be commenced no later than 70 calendar days from the date of such motion. That would be around May 15th. Now, there are exceptions to that rule. Here they are. If the delays due to congestion of the court calendar or an emergency, then the 70-day rule may be circumvented. The defendant, if he or she is moved for an early trial, is released from jail before that 70-day period expires, then there's not an issue. Or if there's an act of the defendant that delays the trial, then, again, 70 days can be circumvented. But here's the crucial part of all of that. If the defendant is held beyond the time limit of this section and moves for dismissal of the criminal charge, the case against the defendant must be dismissed. So in short, if we don't get that trial date that the defense is asking for and the state or the court doesn't see that there's an exception, he could be released from jail or have his charges dismissed as soon as May. Let's bring in our think tank to see what they think about this filing. Joining us tonight from New York City, former senior homicide prosecutor and founder of the Villalona law firm, Bernardo Villalona, is with us here on a Friday night. Also with us in Los Angeles, California, Deputy Public Defender for LA County, Philip Dubé, and in Washington, D.C., the attorney who represented Johnny Depp in his defamation case and fellow of the American College of Trial Lawyers, Ben Chu, is with us. So good to see you all here, the think tank, on a Friday night. Bernardo, let me start with you. Is this a risky demand by the defense to say, we want this trial to start in 70 days or else?
Well, every defendant is entitled to this speedy trial. It is guaranteed by the U.S. Constitution as well as the Constitution of every state. So if Richard Allen is requesting a speedy trial, and for his defense team to ask for it to be sped up within the next 70 days, it must be that Richard Allen's defense team is ready to go, because I hope they don't think that the prosecution is not going to call their bluff. So they must be ready to go and have evaluated all of the evidence. The question will be, is the prosecution ready? Because even though the prosecutor, majority of times they file their charges and they answer ready, they're not ready, meaning that they're not ready to go forward with a trial. So let's see what the judge decides. And I hope that he does get a trial date within the next 70 days as he's entitled to have.
Yeah, this trial is currently slated for October, so it would move things up 5 months before they were anticipating going to trial. Philip Dubé, to Bernardo's point, do you think, based on what we've seen in this case, the filings, the way the evidence has been coming out here and there, do you think the prosecution is ready to present to a jury?
Oh, they will be. Are you kidding? This has a lot of national media attention. The last thing they're going to do is suffer a dismissal just because they didn't have their evidence and their witnesses ready to go. They have ample resources to hand deliver all the subpoenas for every single witness and get everybody into court on the day of jury selection. They'll have everybody there, I have no doubt. And there is a statutory right to a speedy trial, even in Indiana. And the remedy, when you assert that right, and the prosecution is not ready, and there is no good cause exception to continue it, is a dismissal.
Wow, a dismissal of the case, or I assume if he's let out of jail, then that would toll the clock as well. Ben Chu, what are the odds that that would happen, in your opinion? We don't see that often, that a speedy trial is requested and then something happens and charges get dismissed and or the defendant gets released.
Julia, I agree. I don't think there's any chance that they're going to let him, let these charges get dismissed or release him.
There's been a lot, thanks Ben for that, there's been a lot of difficulty with his being behind bars. We've got some pictures that his defense team has shown us, and they say that he's in deplorable conditions behind bars, with the possibility of him being released kind of in the air with this demand for the early trial. We want to take a minute to talk about some of those jail conditions so far. Now, since the beginning, his attorneys have been very vocal about this with their concerns regarding his treatment. These are the images that they say show him before and after his arrest that show a decline in his physical and mental health as a result of this incarceration. Let's take a listen back to one of the former attorneys for Richard Allen. Our Court TV senior producer, Barbara McDonald, she sat down with him in a one-on-one interview. Here's what he had to say regarding the issue.
And you've handled death penalty cases. Have you ever had a pre-trial defendant treated the same way as Richard Allen?
Never. Never. In my 25 years or Scremen's 25 years have we ever had a murder client held pre-trial in a maximum security facility and then was transferred from one maximum security facility to another. He is 5'6", 120, 130 pounds. He is not a physical threat to anyone. From all accounts, he's been a model citizen because he's locked down 23 hours a day. We told the confinement officers that we wanted him unhandcuffed so we could shake his hand and maybe have him sign documents, and they weren't budging on that.
That was his former attorney, William Libreto. Some things have changed since then, some moving of Richard Allen, but there were some interesting filings that were recently made by the prosecution having to do with Allen's mental health. Prosecutors have been trying to get his psychological evaluations, his mental health records. And here's a look at their latest attempt, their third request for those records. They claim that the defense has now filed a verified ex parte motion for a hearing on funding for expert services. They want to get state funding for that. And within this motion, the state says that the defense is asking the court to approve the funding for Dr. Polly Westcott, she's a clinical psychologist, and for a confession expert. It goes on to say that it's clear from this statement and other affirmations made in that motion that the defense intends to challenge the multiple confessions that the defendant has made while incarcerated. They say it's further clear that the defense intends to make the defendant's mental health an issue in this matter. And in order to address this, the state needs to review the mental health records and have an opportunity to consult their own expert. Now, you may have noticed that the defense motion that the state cited was referred to as a verified ex parte motion, which we'll talk with our think tank about what that means. But here's what they had to file after that. They had to quickly withdraw their request after some attorneys weighed in and said there's something unethical about that. The state was notified, this is the state withdrawing and saying that they were notified by the defense on March 7th, 2024 via email that the filing should have been sealed and that the state should not have been given access to it. Knowing that it was not intended for the state to have access to these filings, the state now withdraws its motion. So we're back to square one. Let's go to the think tank for their reaction on all of this. Ben Chu, can I start with you? Your reaction to mental health records and how important they are to be protected.
Yeah, it's extremely important, and those sealed materials should have stayed sealed, so it was perfectly appropriate for the government to withdraw that motion forthwith.
Yeah, Philip, we don't know exactly the details as to how they were able to see them, but talk about ex parte, what they should have known just from the title.
Well, what happens is, as a practical matter, whenever the defense has a client who may have some mental infirmities, they can get the court to appoint a psychiatric or psychological expert to evaluate the client. And everything that is said during that evaluation is actually attorney-client privilege. They are not seeing a doctor for purposes of treatment and therapy so that the psychotherapist privilege attaches, but rather they are acting as an arm of the attorney-client relationship. And absent a waiver of the attorney-client privilege or the work product privilege or the tendering of those documents, the actual reports in court, in evidence, they're off limits. They are privileged. They are inadmissible. And I must say, to the prosecution's credit, I actually hold them in high regard for withdrawing that motion, because when they saw what they did was not proper or was unethical and certainly not allowed by law, they withdrew. And that's understandable. Lawyers make mistakes all the time, even the prosecution. The good news is they at least did not get the actual substantive reports.
That's a good point. It did not get to that level. Bernardo, can you weigh in on this, your thoughts on it? But also, where's that line for these records that you can allow your attorney to see, but once a defense does get out there, do you think the prosecution will be able to see at least some of those records?
Absolutely. If the defense is going to launch any type of defense having to deal with mental health issues or the voluntariness of any statements that were made, then the prosecution is entitled to those records, because the prosecution will be entitled to also hire an expert to examine those records and to serve as a witness at the time of trial or if there's a hearing prior to the trial. My question would be is that if the defense is going to go forward with some kind of mental health defense, then that is going to delay the trial, and that will entitle the judge to let the prosecution know that, yes, they are entitled to a delay and that it won't count against the prosecution in holding that Richard Allen must be released. Because when it comes to these defenses, they are very lengthy when it comes to examination by any mental health expert to conclude or make a conclusion at the time of trial and also even before the time of trial. That causes a lengthy delay.
Oh, that's right, Bernardo. There's that exception that if the defendant creates the delay, then they don't get the 70-day deadline. So we will see how that plays out, how this judge reacts to it. That's all the time that we have right now for this one. But there is a hearing March 18th that may discuss some of these issues. We'll, of course, bring it to you here on Court TV. But be sure to stick around. The think tank is staying with us. We've got more this hour coming up next. She claims her 2-year-old son shot her 5-year-old daughter in a tragic accident. In the end, the jury didn't buy it and found Tennessee mom Robin Howington guilty of reckless homicide. Tonight, we review the trial and what's next for the now convicted murder mom.
Ion kicks off the National Women's Soccer League starting March 16th.
She scores! She's on fire!
See the full schedule and find where to watch at IONNWSL.com.
We have some breaking news from Utah in the murder of Gabby Petito. Petito was murdered by her boyfriend, Brian Laundrie, while the pair were traveling across the country in a van. At one point during their trip, just days before her murder, the pair were stopped by the Moab Police Department over an alleged domestic violence incident with Brian Laundrie. Petito's family has attempted to sue the Moab Police Department for failing to separate Brian from Gabby, claiming that if they had done that, it could have prevented their daughter's murder. They argued that the police didn't handle the situation correctly, that they saw signs of physical abuse evident on her face, which she confessed to having been caused by Brian Laundrie. Now, today, court documents obtained by People magazine say that the stay that was put on the suit, the family had sued the police department for $50 million, but it was paused with a surety bond of $200,000 that the attorneys say they couldn't pay. So now they have removed certain officers and police entities, the individuals from that case, and now they are just suing the police department. So that stay has now been lifted by the court, meaning the Petito parents can continue with suing the department for their alleged mishandling of this situation. Let's go back and take a look at that body cam footage surrounding this incident.
But you tend to have a lot of anxiety and stress?
I have a lot of anxiety.
And what's his name? Is it Brian? Is he usually pretty patient with you?
Yeah, but it just makes me upset. I know that he definitely gets frustrated with me a lot because I have a lot of anxiety and he definitely has anxiety too.
Oh, that could be a bad combo if you both have anxiety. You know, I have anxiety too, and you know, my girlfriend's really, really calm, and she has a way of taking my anxiety and bringing it down. But my ex-wife, that's why she's my ex-wife. I'm just sharing, I know it's a little personal, but to help you understand, we would feed off each other's anxiety and it would spiral. You know what I mean? And it doesn't matter how much I loved her. It may be bad for your soul.
All right, let's bring back in the think tank. They are with us, Bernarda Villalona, Philip Dubé, and Ben Chu. Philip Dubé, your thoughts on the strength of their case against the police officers and now just the police department?
I got to tell you, you know, here I am, the commie, pinko, bleeding heart, liberal, warm and fuzzy public defender. I would absolutely defend the cops on this one, and I'll tell you why. First of all, if we're all really honest, and I don't know if Ben and Bernarda will agree, even if they would have arrested Gabby or Brian, isn't it speculative to say that she would have lived? You know, maybe they would have hauled him in, maybe the DA would have rejected a criminal filing. Or maybe they did file, you get out for time served, and then what happens? The honeymoon is on again, they take off on the road, and then she's killed. So there's really no way to know for sure that it would have saved her life. Second, to be fair, at the time under Utah law, you could only arrest somebody for domestic violence if there was evidence at the scene of an intent to injure. Right? So not an intent necessarily to use some force, to shove, push, slap, whatever the use of force may be. Unlike California, where you could be arrested just for a use of force, there actually is that mens rea, that criminal state of mind where you have to intend to injure. And Gabby basically told the cops, no, that wasn't the situation. So nobody got arrested.
Let me bring in Ben Chu on that. Ben, you are no stranger to multi-million-dollar suits and winning against entities. Can you talk about the change now where they're not going to be able to go against the individual officer, the police chief, but now there was this Utah rule that kept them from being able to go forward, and now they're just going forward against the police department?
Yeah, I think Philip makes several good points as usual. I think this is going to be a difficult case for the plaintiff, but I think it's a potentially winnable case. There are always issues of quasi-sovereign immunity when you're going after government entities and individuals, so it's not surprising that they had some hiccups along the way. It's a challenging case, but I think it's going to be one that will go to the jury.
One that so many people are certainly watching for and looking for accountability, even in a case like this. Let's turn our attention and get Bernarda's input on this case now that we have been watching here on Court TV, and we had a verdict in today. The Tennessee case against Robin Howington. She was accused of fatally shooting her 5-year-old child, and in her police interrogation, she first told a completely different story as to how that shooting went down.
I didn't even hear the door open because it was just the screen door. I had the other door still open because my purse was in the car still because I had to carry Gavin in because he didn't have shoes on. So whoever, all thing I seen was a black dude come in and I heard a gunshot and then I looked at my baby and then I look at him and his eyes got big as I don't know what. Like I feel like it was meant for me.
As you heard there, Howington initially blamed the murder on a stranger. She said a random African-American man came into her home and shot her daughter. Then she later pointed the finger at her daughter's father. Then she went on to even blame her 2-year-old son for the shooting. So the jury got to hear all of her stories because she took the stand, and then they decided whether they believed any of them.
Ms. Howington, if you would stand and face the jury. Mr. Martz, as to the first count of this indictment charging first-degree felony murder, has the jury reached a unanimous verdict?
Yes, we have, Your Honor.
And that verdict is what, please?
The jury find the defendant, Robin Rebecca Howington, guilty of reckless homicide,
As to the second count, alleging aggravated child neglect, has the jury reached a unanimous verdict?
Yes, sir.
And that verdict is what, please?
We, the jury, find the defendant Robin Rebecca Howington guilty of aggravated child neglect.
As to the third count, alleging aggravated child neglect, has the jury reached a unanimous verdict?
Yes, sir.
And that verdict is what, please?
We, the jury, find the defendant Robin Rebecca Howington guilty of aggravated child neglect.
As to the fourth count, alleging, initiating, or filing a false report to law enforcement, has the jury reached a unanimous verdict?
Yes, sir.
And that verdict is what, please?
We, the jury, find the defendant Robin Rebecca Howington guilty of initiating a false report to a law enforcement officer.
As to the fifth count, alleging tampering with evidence, has the jury reached a unanimous verdict?
Yes, sir.
And that verdict is what, please?
We, the jury, find the defendant Robin Rebecca Howington guilty of tampering with evidence.
And as to the sixth count, alleging attempted tampering with evidence, has the jury reached a unanimous verdict?
Yes, sir.
And that verdict is what, please?
We, the jury, find the defendant Robin Rebecca Howington guilty of attempted tampering with evidence.
Barely any reaction there from the defendant hearing her fate. Robin Howington seemed rather stoic during it all. In a crucial part of her case, though, she did decide to take the stand in her own defense, and we saw a lot of emotion and animation from Robin Howington.
What happened? What did you do?
I made sure the kids was okay, and I went outside to smoke and move my car.
When you came back from moving the car, what did you do?
I was walking up to my house, and it's a glass door, and I seen a flash of light go off. And when I walked in, the was screaming and crying, and the gun was on the ground.
There's some tissues up there in that box. And did you see where Destiny was at that point?
Yes, she was on the couch.
And was she moving at all?
No.
Did you try to speak with her at all?
Multiple times.
I'm sorry.
Multiple times.
And did she ever respond to you at that point?
No, sir.
Now, what was going through your mind at that moment?
I couldn't believe what was going on.
What did you do?
I got the gun and I took it outside.
Why did you take it outside?
To cause any more harm.
When you made that 911 call, did you know Destiny had been shot?
Yes.
And you told them that a black male, unknown black male, entered the door and fired a shot and shot Destiny.
Yes.
Why did you tell that story to 911?
Because I didn't want to live with the fact that he had shot his sister for the rest of his life.
The story that an unidentified black male had shot from the door was not true, was it?
No, sir.
Right here. You tell the officers that you don't have a gun, right?
Yes, ma'am.
You tell the officers that it would surprise you if a gun was found outside your home, correct?
Yes, ma'am.
But seeing as how you were the one that put the gun out there, that's not true, is it?
I was trying to protect my son. I was not in my right mind.
And at that time, you had also asked multiple people to go and pick up that gun, had you not?
because I did not want it to come back to. Do you not understand what I'm saying, ma'am?
Miss Howington, my question is, at that point in time, you had asked multiple people to come and pick up that gun that you put outside your home, had you not?
To protect.
It's a yes or a no. Had you asked multiple people to get that gun from outside your house, yes or no?
Yes, ma'am.
Okay.
Now she may explain her answer, Judge, when she's answered yes.
I think she has, but if you want to, again, explain your reasoning for doing so.
I was trying to protect my son, and nobody wants to accept that. What would you do?
Can I?
The jury simply didn't buy her version of events. The think tank still with us. Bernarda Villalona, Philip Dubé, and Ben Chu. Former prosecutor Bernarda, I have a question about this one. If she didn't tell these different stories, if she started with police with just the story of my 2-year-old got access to my gun and shot his sister, would a prosecutor still charge her with reckless homicide?
Absolutely. I think a prosecutor would still have charged her with reckless homicide, because the question would be, they would have charged her with reckless homicide. And the reason why is that because they would have determined that she was reckless in the sense that she had a firearm that was laying around for her 2-year-old child to be able to find and to use and to actually fire. So they would have charged her still with the reckless homicide, because you got to think that still, because mom had access and knowledge that there was a firearm in the house, she should have taken the necessary steps to have been able to put it away where her kids wouldn't have had access to it. You got to think it's the same case with the Crumbleys, in the sense that the gun was left accessible for this 15-year-old to be able to access it whenever he wanted, outside of the supervision of his parents. So the same thing here. The thing is that the jury made a credibility decision, and that credibility decision was easy for them to make, being that she gave multiple different statements. And it's just not plausible and feasible for someone to think that a 2-year-old is able to get the gun, also hold the gun, position the gun, and then apply the necessary pounds of pressure onto that trigger to shoot that gun and aim it at his actual sister.
Yeah, Philip Dubé, do you think that they bought any part of her story? Did they not care because she had lied so much and had so many other problems that even if the 2-year-old did get the gun, that it didn't matter, she's still guilty of something? Or is there something different you would have done with her defense to potentially get a different outcome for her?
Well, first of all, I think this is absolutely a fantastic outcome for her. And yes, I think the jury believed her, because in the end, what they convicted her of is what she admitted on the stand. And that was she left basically a loaded gun laying around for her other kid to get a hold of and shoot Destiny. That is a crime. You know, the good news is she's only looking at 2 to 12 years for that. Whereas had she gone down on the felony murder, it carries life in prison. So she was actually found guilty of what she actually did and what she copped to on the stand. I think it was brilliant. And she's a lucky lady. You know why? She has a full life ahead of her. She'll get past this. She can move on. And she'll have light at the end of the tunnel.
Ben Chu, how do you rate her display on the stand?
I didn't find it convincing, and I don't know that she'll get past it. I mean, I don't know how you would get past being responsible for the death of your own child. Legally, I understand Philip's point, but to the extent she has a conscience and normal human feelings, I don't see how she gets past it.
It truly seemed difficult for her on the stand, but the jury simply did not think that it swayed her away from that culpability for this crime. Unfortunately, we do have to squeeze in a break and step aside, but the think tank isn't going anywhere. Don't you go anywhere either. We have much more ahead. A former Idaho State Trooper is on trial, and we have the very latest out of that trial against the jealous ex-lover murder trial.
Dr. Nara and Tom, specifically, what was it about what Dr. Nara did with the tongue and what were findings about the tongue that was important to you?
Several things. One, the analysis and dissection of the tongue wasn't done at the first autopsy by Dr. Howard, but because, for whatever reason, Dr. Howard saved the tongue, she was able to go back and actually figure out the path of the bullet through the tongue. And the path of the bullet in this case is very important. And what she documented, photographed, and then wrote up is that the bullet path through the tongue is downward. I mean, going from the top of the tongue, through the tongue, out the bottom of the tongue, and then into the neck. And in this case, the bullet has a downward wound path. And the bullet ends up here, but when we look at the tongue and where it goes, we've got, in my report, I actually put a red line to show that the path is downward from inside the mouth.
And I've got a close-up of that. If that helps, it's 20 millimeters in.
Yes, again, it's the bullet passes through what's called the second cervical vertebra, which is right here. So it's downward. When you're looking at intraoral gunshot wounds, whether suicide or homicide, suicides go up, homicides go down. And this is not only supported by the literature, but my experience of looking at patients that come into the ER that have their face blown off or deceased or at the autopsy table. So the literature says, one, you have to have the gun. If you're suiciding, it needs to be in a comfortable position if you're going to shoot yourself. But those individuals that do that, based on the literature and the research, those go up. The homicides, the bullet trajectory, the wound path is down.
So was it murder or was it suicide? That was an expert witness testifying today in the case against Daniel Howard. Howard is a former Idaho State Trooper. He's pictured here with his wife, Kendi. After many years of marriage, things got rocky. The couple started the process of divorce. That was until Kendi Howard was found dead in the bathroom of the family home with a gunshot wound to her head. Police initially thought it was a suicide, but then over 2 years later, Dan Howard was arrested and charged with her murder. Authorities claim prior to being shot, she had actually died from asphyxiation. Court TV anchor Julie Grant has the story for us tonight.
I knew right away, there's no way that she would have shot herself.
February 2nd, 2021, 48-year-old Kendi Howard was found shot to death in the bathtub at the home she owned with her estranged husband, Dan. Her daughter spoke with local station KHQ and described how Dan told her about what happened.
What did he say? That there had been an accident. Yes. And she was gone? He didn't even tell me that. He just said that she shot herself.
Kendi and Dan Howard had been married for more than 25 years, but were in the process of divorcing. Her death initially appeared to be a suicide, but prosecutors believe she was killed before she was shot.
Evidence will show that Kendi died of asphyxiation. That's the result of a carotid restraint, something Dan knew how to do.
Dan's defense team says that evidence at the scene shows she died from the gunshot wound.
Now, one of the scenarios is that she held it with her thumb on the trigger, which would lower that angle of the gun. She also, you'll hear, has bruising on this hand from the impact of the gun.
Prosecutors say the motive for Kendi's death was money. Dan was a retired Idaho State Trooper. He and Kendi had about $2 million in assets that would have been split between them in the divorce. Dan Howard faces 1 count of murder and 1 count of domestic battery from an alleged assault in July of 2020.
You don't want to think that someone you've known for your whole life could actually do it. And I tried for about a week, just like, well, maybe this could have happened. Maybe this could have, nothing would fit. Nothing fits into place to make it make sense.
Today was day 5 in the case against Howard, and so far we've seen some very impactful evidence. Let's look back at body cam footage the jury saw of the moment Howard allegedly finds out from authorities his wife is dead.
I'm sorry to inform you that your wife is passed, sir. I know this is hard, but when is the last time that you saw your wife alive? I know this is tough. How long ago? Can you recall? What time is it? Did you call 911 when you heard the gunshot? No. Okay. I didn't. What? Oh no. How was that? I didn't think it was a gunshot. I was downstairs getting going. It sounded like something hit the floor or something. I don't know. When was the last time you saw your wife before she went to go take a bath? Hour and a half. Okay. Hour and a half or something. I don't know. Okay. I really don't know. I figured out it's about 11:15. Maybe 9:30. 9:30 or so. I think. Okay.
As we look ahead in the jealous ex-trooper murder trial, testimony in this case is going to pick back up on Monday. Coming up next, in tonight's Tank Takes, a man standing in line at TSA tells the lady he has a bomb in his bag. When he's pulled to the side, he tells police he was just hitting on her and trying to be funny. We're wondering tonight, what's your best pickup line?
The first parents in America to be charged in a mass school shooting.
Involuntary manslaughter and 4 counts of it.
The gun recovered from the shooter was the same gun that was purchased by his father.
Jennifer was found guilty.
Who is responsible for storing the gun?
Now the school shooter's father is set to stand trial.
My husband is.
The school shooter dad trial. Live coverage weekday mornings, 8/7 Central on Court TV.
Welcome back to Closing Arguments. It's time for tonight's Tank Takes. This is where we take those stories that don't exactly fit into the rest of the show and we get our think tank experts to weigh in on them. There they are, the Friday Think Tank. Still with us, Bernarda, Philip, and Ben. Is everybody ready? There are no wrong answers. Let's go. Here's story number 1. We have titled it Mixed Drink. A mother in Texas was arrested for concocting this harmful drink for her 10-year-old son's bully, resulting in the targeted child's hospitalization. Here's a look at the 45-year-old mother, Jennifer Lynn Rossi. She reportedly mixed lemon juice, vinegar, salt, and Gatorade in a sports bottle and told her son to have it out and give it to essentially a classmate who had stolen his drink the day before. And that ended up sending that other bully to the hospital. Officials report that Rossi said she intentionally mixed the contents of the drink to prevent her son's drink from being stolen at school by the other students. So our question tonight is this criminal or teaching the bully a lesson? Bernarda.
That's a different way. That's a different way of handling it. I know when I was younger and we used to have issues, my mom would stay at the corner and was like, you're going to fight that person or you're going to have issues when you come home. So that's a different way of dealing with things.
Philip, is it a criminal or is it a security precaution?
Neither. It's pure retaliation. And way to go, Mom. I mean, this was not poison. What was it? It was vinegar with Gatorade and lemon, okay? If anything, it'll help the kid clear up his irregularity. And that's about it, okay? Seriously, it's not poison.
Ben, does it matter that the kid was fine after a while, went to the hospital? I don't know, may have gotten his stomach pumped and then went on his way?
I would say hell hath no fury like a mother scorned.
Oh, that is the truth. That is the truth. Let's move on to our next story. We're titling it Flirting with Danger. There was a Florida man who claims that he was attempting to flirt with another traveler. He made a wisecrack about having a bomb in his bag at an airport. According to police, 70-year-old Alan Berinsky told police he was trying to be funny when he made the remark at Fort Lauderdale's Holiday International Airport. He was sitting at gate G11 in the terminal when two witnesses overheard him tell another passenger, quote, "If the bomb in my bag goes off prematurely, I apologize to your family in advance." According to the police report, he was arrested, but he's now out on a $7,500 bond after pleading not guilty. Our question for the think tank is, what's your best pickup line? Philip, let's start with you.
Oh, that's a lousy line, especially at 70, you know? I mean, the good news is at that age, he doesn't have to introduce anybody to his parents. They're long gone, you know? So.
Ben, can you rework that into a better pickup line? What's the best one you've heard or used?
I just say that joke blew up in his face.
Bernard, I know you've heard some pickup lines.
Girl, I've heard it all. I've heard it all. I've heard it all. I'm not even going to give any pickup lines because obviously it didn't work.
It didn't work. Do you think he should have been taken away? Is that a little bit much?
Oh, no, he should have been taken away. Come on, you have to read the room. Read the room, sir. You're at the airport, in an airport.
Absolutely. Let's get to our final story before we have to go tonight. We have titled it Jailbird. You don't want to miss this video. In Colorado, a runaway emu was caught by the neck by a sheriff's deputy. Here's the video of that incident, which was posted to Instagram by the police. Take a look.
Nope. Thanks, buddy.
All right, our final question for the think tank as we see this sheriff's deputy take the emu by the neck and sort of gingerly get him back to where he's supposed to go.
Got my hand
Bernardo, what do you think they charged the bird, the jailbird, with?
Freedom.
All right, that's all the time we have for tonight. Thank you all for playing along. Have a great weekend. Bernardo Villalona, Philip Dubé, and Ben Chu, we appreciate you coming on. We also have an important programming note for you tonight. Vinnie Politan Investigates has 2 brand new episodes on the Idaho student murders. It premieres tomorrow. It all starts Saturday morning, 10 Eastern, right here on Court TV. We also have an important missing child bulletin for you. Take a look at your screen. Joseph Isaiah Acosta Rangel is missing tonight. He was last seen March 6th in Salinas, California. He's 16 years old. If you have any information on where he may be tonight, call 911, the Salinas Police Department, or the National Center for Missing and Exploited Children, 1-800-THE-LOST. Those numbers are on your screen. Have a safe night. Thanks for being with us. I'm Julia Jenae in for Vinnie Politan.